consultant. This week, the state of Florida is celebrating Mediation Week, and this program marks part of the DRC's contribution to this annual event. And I hope that everyone in the ADR community has been able to observe and has really found something special this week to promote mediation and to learn a little bit more. Before we get started this afternoon, I have some housekeeping items I want to share with you. First, we'll be using PowerPoint for our review of the MEAC opinions, but since some people are attending through audio only, we're gonna read the slides. And I know that when I'm attending a presentation, sometimes it's kind of bothersome if the person just sits there and reads the slides, but we may seem to be doing that, but it's for a particular purpose. We want to make sure that people who are only able to attend by audio, get as much as they can out of the slides also. And then the next thing is for our Q&A session, we'll take questions via the chat option on the side of your screen. So please put your name also next to your comment or question. And this is for a couple of reasons. Number one, we'll be able to address it, and you'll know that we're addressing you and your question. The other thing is that if we do not have the opportunity to answer your question during the webinar, we will be able to follow up with you in the next several days and hopefully get you an answer or a more complete answer to your question. Finally, this program is approved for 1 hour of mediator ethics and 1 hour of legal ethics for those people who are members of the Florida Bar. The course number is noted during the beginning segment of our PowerPoint presentation, so you'll be able to get that and get all the credit that you deserve for attending. Prior to the course, you should have received a link to the workshop materials. The link will be shared again in a follow-up email from Zoom. You should receive it tomorrow. And lastly, this program is being recorded and will be posted on YouTube in the near future for the benefit of all mediators and others who may be interested in the ADR community. So we hope you enjoyed the program, and away we'll go with our PowerPoint.
Thank you, Tad. And I'm Kimberly Kosch. I am the Senior Court Operations Consultant at the Dispute Resolution Center. This week, I'm celebrating my 26th year anniversary at the DRC. And I know many of you out in the field who are watching or listening to us. And I wish you a happy Mediation Week. And I would like to thank you for all of the time that you have spent with the DRC supporting our efforts and working on training issues with us. So we have an ambitious schedule for you today. And like Tad said, although we know that you can read, we're going to be going through the PowerPoint so that you can follow along both by seeing and hearing. So some basic information to get us started. Like Tad said, this program is eligible for CME and for Florida Bar Ethics credits. So the course number for Florida Bar members is on the screen. You can write that down and self-report it. The materials that you should have received also have this number on the agenda. So it's in 2 different places. If you are watching this after the live event, you can earn CME for this course for 18 months following our broadcast today on October 22nd, 2021. So there is the opportunity for those who are listening to our recording to earn that credit. In addition to the handouts that should have been provided by your ADR director, we do have the materials for this program on our website. Currently, the materials are limited to the handout and certificate of attendance. When the program is done, we will also post the PowerPoint, and links to those resources will also be noted when we post our YouTube recording. Today, we're talking about Mediator Overview 2021. As most of you know, the Mediator Ethics Advisory Committee is a committee that renders ethical opinions based on requests from certified and court-appointed mediators. The common acronym for this group is MEAC, and their authority to do their work is contained in Part 3 of the Rules for Certified and Court-Appointed Mediators. The MEAC takes in written questions, and although not a hotline, they do produce a written ethical opinion, and that opinion and the question are posted on our website anonymously for the benefit of all mediators. If you have an ethics question and would like to reach the MEAC, you can send your question to us at the Dispute Resolution Center, and we will forward it again anonymously to the MEAC. Generally, it takes them 90 to 120 days to render an opinion. The MEAC is a group of 9 individuals appointed by the Chief Justice for 4-year terms that serve around the state, and they are volunteers. And I would like to thank all of our current and past MEAC members for their service and for helping us shape the ethical practice of mediation in the state of Florida. As you'll see, we post the MEAC opinions not only online, but we list new opinions in our newsletter, The Neutral. In addition to the exact opinions themselves, we also have 2 indexes by subject matter and by chronological order. Over the last 25 years, the MEAC has issued over 252 opinions, which equals about 10 opinions per year. And like I said, these opinions help shape our ethical practice. For the subject matter index, those subject matters are broken down into 6 different areas. So for the ease of reference in you looking and finding questions and answers in a specific topic area, we have mediate, advertising and marketing, advice, opinions, and information, business practices, confidentiality, conflicts of interest, and procedures. These subject matters were created by DRC staff to help organize and form an opinion index for you. Those can be amended from time to time. And I do often wonder to myself in the last year and a half if we won't soon find ourselves with another heading on remote practice. All right, Tad, I think that I'm done with the overview of our introductory information. If you want to go ahead and dive right into the first opinion from 2021.
Thank you, Kimberly. I do want to point out also, though, that if you're searching for an opinion on a particular subject, if you go into one of those categories that Kimberly just showed on the last slide and open it up, there are summaries of all of them. And on that page, you can go up in your web browser into the little function that says find on page, and you can actually search for various words that may help you find an applicable opinion more easily and more quickly, even within the results as we have cataloged them. So that may be a helpful hint for people. I've been having to use that as I'm learning the nuances and a lot of the history of the MEAC opinions and everything. So now on to MEAC 2021-001, which is the first opinion issued by MEAC this year. The summary says, I am doing a pre-suit mediation involving a homeowner and an HOA. It will be a Zoom conference. The attorney for the homeowner wants 2 other homeowners to attend without the HOA knowing it. Is it appropriate for the attorney to allow the 2 other homeowners to participate on Zoom in this fashion? What are my ethical responsibilities as a mediator? And the summary of the opinion that the MEAC issued says, as stated in MEAC opinion 2019-004 and previous opinions 2008-006 and 2006-007, Self-determination is a bedrock principle of mediation, and the parties decide who will attend and participate in the mediation. Parties cannot consent to attendance and participation of others in the mediation if they are not informed of their presence. So, I mean, this would tend to be, and a lot of times what helps me with virtual things is to analogize it to, the in-person world, and whether or not you would let two people, unbeknownst to one of the parties, listen through the wall at what was being said. So that's kind of the way that I think about that.
And Tad, wouldn't that also raise confidentiality concerns if there are two people participating in a mediation unbeknownst to the other one of the parties? Right.
And that is a good point. I believe they may have mentioned that in the opinion. And because confidentiality applies to keep all of the information, all of the conversation, discussions, and everything within the walls of the participants. And you can't be a participant without all of the parties' knowledge. So allowing that, this would be similar also in effect to, once again, to analogize it to the in-person world, is if the HOA participant, or excuse me, the homeowner was the one wanting the other two homeowners to participate. But if this homeowner left the caucus room, or not the caucus room, the main room, or the caucus room, and went outside and immediately repeated verbatim everything that had gone on, that's pretty obvious that it would violate the confidentiality restrictions. So there are at least a couple of issues with the proposed actions in this question.
Okay, great. Thank you. I'm going to review the next question, MEAC 2021-002. And it is not uncommon for the MEAC to receive an inquiry that consists of a summary of facts and then actually more than one question. So this question, I believe there are three questions to this one inquiry. So the first one is, are Florida Supreme Court certified and court-appointed mediators who are subject to the Florida rules for certified and court-appointed mediators prohibited from conducting bilingual mediations in the state of Florida? Number two, if bilingual mediations by Florida Supreme Court certified or court-appointed mediators is acceptable, is writing the original version of an agreement in one of the languages used in the bilingual mediation prohibited? Actually, it was just two questions. So in first part, MEAC determined that is an overall statement that they're going to affirm previous opinions that say that mediators should not serve in dual roles as both mediators and interpreters simultaneously. And if you have followed the area of court interpretation or bilingual mediations or dual roles, you'll know that this is not the first time that the MEAC has been asked a question about whether or not the actions taken in those types of mediations are appropriate. In the MEAC, not just for interpreters, but for other areas, has been very clear that the mediator should only be participating in the mediator's role. The mediator cannot be an advocate. The mediator cannot be a notary. The mediator cannot be an interpreter at the same time. So their next statement was that mediators shall honor the rights of self-determination and not make substantive decisions for them, including determining language agreement. However, a mediator may advise the parties that the agreement filed with the court must be in English. So in this opinion, the MEAC, the summary of it goes back to self-determination of the parties, but there is no prohibition against a mediator conducting a mediation with bilingual parties one party that doesn't speak the same language, however, or all parties that don't speak the same language, however you define bilingual mediation. The key is that, again, the mediator cannot serve as an interpreter. So if I was conducting a mediation and the only language I am fluent in is English, and one party speaks Creole and the other party speaks Russian, if there are appropriate interpretation services for both parties, we could conduct the mediation in any of those common languages, including me, the mediator, might need an interpreter to speak to both of the parties in a different language. So there's nothing that prohibits people speaking different languages. It's just that interpretation services need to be provided by someone else other than the mediator. In addition, I know that, and we probably all know that the courts require that agreements submitted to the court be submitted in English. However, not all agreements are submitted to the court, and it is possible for a mediation to conclude with an agreement written in a different language that the parties take to a translator, and the translator will put that document into English for filing. So there are ways to capture in writing all of the different types of languages that may or may not have been spoken, and there's opportunities for translation services. Again, the key is that some other professional who's qualified will be taking on those roles, not you, the mediator. So again, self-determination as to what language the mediation will be conducted in and what language the agreement will be written in is up to the parties. Now, I know that probably some of you, like me, only speak one language. So if the only language I speak is English and the parties need someone who speaks Spanish, unless myself, the mediator, gets an interpreter, I'm not going to be able to conduct that mediation. But that doesn't mean that I have the ability to tell the mediators it can't be done. Maybe it can be done by another mediator, just not you. Or perhaps you want to make give parties resources so that they can mediate with you in a language you're all comfortable with. So again, there is prohibition against dual roles. There is no prohibition about bilingual mediations. There's nothing that says that natural speakers of a language who don't need interpreters can't speak in their native language during a mediation if all the parties understand. You really just need to make sure that all of these items are discussed beforehand, and that if you're working in a court program, you obviously need to follow your court procedures. So if there are barriers to that function because the parties might need to submit a stipulation right then and not have the ability to take it to a translator, those things need to be worked out, but it's not saying that it can't be done.
Yeah, and Kimberly, the one important thing about that MEAC opinion is there's a differentiation between conducting a mediation in a bilingual mediation and the service of interpretation, which is definitely a distinct and concrete service within the business world and certainly the court world.
Right. And Tad, just to say it on a finer point, if you and I and our colleague Stephanie McCarty were all doing a mediation and we all spoke Russian, we could do the entire mediation in Russian. We could also choose that we know enough English to put the agreement in English if we all know enough about it, or we could decide that we want the agreement written in Russian and it'll just need to be taken to a translator before filing in court if it's indeed a document that needs to be filed. So
right, and of course translation is the written cohort to interpretation as a spoken thing. So translation is also a separate and distinct service.
Right. And just a reminder that the ethical standards, the rules for certified and court-appointed mediators, do not require that the mediator write the agreement. The rules, the ethical rules, require that the mediator discuss with the parties methods for implementation and memorialization. Now, if you are a mediator in a court program, and probably most of you are, there is an expectation because of your role as a mediator for the courts that you will write the agreement, then you need to follow those local standards. But the ethical rules themselves do not require that the mediator write the agreement. Okay, I think we're ready to move on to the next one,
Right.
Tad.
And this is somewhat related to that, to the last little thought that you had on the end of the of 002. It says, if the mediator has the parties sign their agreement electronically, would that be considered that the mediator has performed another function? And should I continue sending their agreements, the parties' agreements electronically to them, and then wait for them to print their paper agreement signed, notarized, and scanned and emailed back to me as I have been doing? And finally, should I continue to delay the filing of my report with the courts, or should I file before having proof the agreement was signed and notarized? The summary of the opinion is a mediator is not required to write an agreement reached by the parties, but it just as Kimberly just said. But
sorry about that, Tad.
yeah, she ran up on my question. That's great. But if they do so, having the parties sign the agreement electronically is no different than having the parties sign the agreement if the mediation was conducted in person. Once again, this is one of those situations where if you just stop for a second and really analogize to the in-person world, and most of us have gotten used to functioning in the virtual world, and so it's becoming easier for us to see these things. So
right. And Tad, during this time of COVID, some of our rules of practice were waived and some were amended by Chief Justice administrative orders. But the requirement that parties sign an agreement was never waived.
right.
So if you are operating in a space where you're not securing signatures on an agreement before you submit to the court, I believe you are in a perilous position, because writing down the agreement and submitting it to the court without appropriate signatures, it really what you're doing is submitting confidential information to the court, because a signed written agreement is not confidential. But up to the point to where the parties both execute the agreement, it has not been signed and effectuated. So it is critically important that you do not submit documents to the court that have not been fully executed. And it can create situations for the parties down the line if they try to enforce that agreement, that there are no signatures on it. That can be very problematic. So we encourage you to follow the rules. I understand that it might have been confusing during COVID on terms of which rules were relaxed and which were not. But signatures on agreements have stayed consistently required.
Exactly. And we have developed over the past couple of years, even before the pandemic hit, there had already been changes in statutes and court rules, basically allowing electronic signatures in just about every aspect where physical signatures were once required. So there are different things, and I'd always check and make sure in the circumstance. But I was just wanting to point out that there have been advancements and there's even under all of the rules and all of the things you have to do, there's even the potential to have electronic notaries, all of these things. So it may be a matter of making sure that all the virtual I's and virtual T's are crossed, but definitely transactions can be memorialized and finalized electronically.
Okay, great. Thank you. And I see that we do have some questions coming in over the chat, and we'll get to those as soon as we can at the end of our session with you. But I do appreciate that you're out there asking those of us. All right, the next opinion, MEAC 2021-004, is a three-part question, and it does have to do with remote practice. The first part of the question is, would it be ethical to conduct a mediation by video conference with two out-of-state parties represented by an out-of-state attorney? The second question is a follow-up. If such a mediation were ethically permissible, can the out-of-state attorney sign the mediation settlement agreement? And number three, if the mediation settlement agreement was to state that Florida law is to apply to the enforcement of the settlement, would that change the answer to questions 1 and 2 above? The MEAC rendered its decision and it posed that the inquirer poses legal questions which are outside of the purview of the MEAC, and therefore the MEAC declines to answer them. So probably about once every 2 years, the MEAC does receive a question that asks, even though they're asking questions about a mediation, those questions have a legal turn to them rather than a mediator ethics term. So when I looked at the submission of this question and the resulting MEAC answer, I don't know who asked the question, and I don't certainly mean to speak for the person who submitted the question, but it seems like that they were concerned about the jurisdiction in remote mediations, and perhaps whether even or not out-of-state attorneys could participate in something involving Florida law. So this is one of those where if you had these types of questions, you should ask someone that can give you a legal authority on them. And while the MEAC always tries to be very helpful, they need to stay within the authority that they are given by the Supreme Court and to just interpretate ethical considerations, not legal considerations. And the way that the MEAC adheres to its authority is very similar to how we request that mediators stick to their authority. You know the things that you can do, and you know the things that you can't do. And if ever asked to do something that you can't, you don't try to fix the problem, but just tell the person that you can't make that accommodation. You're not able to practice in that way. So again, knowing your own authority is very important. And here MEAC is confirming that they don't have the authority to help this questioner. Right, I think we're on to our next one, Tad.
Yes. Question 5. Advisory opinion MEAC 2011-003 notes that confidentiality of mediation is not intended to cloak or provide protection for the professional misconduct of any party or participant during the mediation process. Does that advisory opinion include potentially false or misleading comments to a court at a post-mediation conference status conference pertaining to mediation communications as professional misconduct during the mediation process, thus allowing reporting here pursuant to the court order without violating mediation confidentiality? The answer, the summary of the opinion is that a mediator should not voluntarily testify in court regarding information learned in court, learned in mediation, unless confidentiality is waived by the parties or such communication falls within the exceptions listed in Florida statutes 44.405. Is that the last slide in there?
Yeah, it is the last slide. Right. Sorry, Ted.
Yeah, and this one presents somewhat of a legal question, but it is also addressed in the rules and, of course, Florida statutes dealing with mediation. You, as it points out, you've got the exceptions that are listed there in Florida statutes 44.405. And then it includes the important statement that a mediator should not voluntarily testify. And voluntarily is this is where your legal interpretation and legal advice would come in. Voluntarily has a meaning within the concept of testimony. And so, certainly a mediator should not unprompted and in any sort of way, just upon a request, in any way testify to any of the confidential information. And this opinion restates that and makes it clear.
I always use I always use as a kind of a guide for confidentiality, that I should not be talking to anyone about repeating communications that occurred unless I can find one of the exceptions in 44-405.
Right. And
right.
that is absolutely the best practice. And sometimes in day-to-day life, we seem to be able to find fact situations that are in the gray areas, but you always go back to, and when we're talking with people on the phone and interacting with mediators, sometimes in just kind of conversation and hypotheticals, you always go back to, what does the statute say? What does it say? And sometimes, and I always go back to the rules and go back to the statutes and read them. And this is a more general kind of statement about things, because you want to make sure that you are reading what the statute or what the rule says, not what you have presumed it meant, and not what you think it says, or not what you thought it said in your last kind of fact situation. Each new situation, the first step is to read the rules, read the statutes, and read what they say explicitly.
Tad, inherent in this answer, though, is that the parties have the ability to waive confidentiality, don't they?
Right. That is by far the easiest answer to any of this, is if all parties to the mediation waive the confidentiality. But sometimes that's not feasible, because the reason you're called to testify is because one party wants you to get the information in there and the other party doesn't. So, but certainly if it's something that both parties, or all parties, I should say, not necessarily just two, but all parties to a mediation waive, then certainly you may testify, you may reveal the otherwise confidential communications.
Right. And you know what I think is important to point out when we talk about confidentiality, Tad, that privilege and confidentiality are two different topics. And I think
Absolutely.
Sometimes that privilege gets overlooked because of confidentiality, or people don't really know what the difference between those statements are. So the privilege that the parties have is to prevent anybody from testifying or communicating unless all parties agree. So I have a privilege that as a party I can assert against you as the other party, trying to prevent you from bringing in these communications. But it's interesting, in some other states, the mediator also has a privilege where the mediator could object to parties repeating things that the mediator has said. But here in Florida, mediators don't have a privilege. Mm-hmm. So if both parties agree that they want to waive confidentiality and they want to go on their local TV show and talk how wonderful the mediation was, they're allowed to do that. And although I know it might cause a little bit of angst amongst practitioners, mediators don't get to have a say in party waivers. If the parties want to waive and they both waive, there's really nothing the mediator needs to be involved with. Isn't that correct, Tad?
Right. Because and it really, that makes the most sense, because as we all know, the mediator is there to facilitate the parties coming to an agreement. The mediator is not there for their own purpose. The only thing the mediator gets out of this would be whatever their fee is. And certainly we have a lot of great volunteer mediators that don't necessarily even get a fee. but the mediator is not there for any purpose within the scope of the case or the issue or the matter. In fact, if they did have any interest in there, that might present a conflict or something. So, I mean, really, it makes the most sense, because the mediator really should have no interest in whether something gets repeated or not. I mean, they should be there as a professional and only there as a conduit.
Right. And while the mediator has an ethical obligation to keep information confidential unless the parties waive it, I will tell you that I know that most parties, even if they received a waiver from the parties, aren't going to go around repeating confidential communications. But most of the time, a waiver of confidentiality is going to be in response to something or for a particular purpose. Obviously for whatever reason, and it would be advisable, just once again, just my individual opinion professionally, to as you say, I mean, even when if you do get a waiver of confidentiality, utilize that waiver only for and reveal the otherwise confidential information only for the purposes that the parties intend, and then not necessarily for entertainment value or socialization otherwise. Right, absolutely. So, and I do have to, many mediators I know not only take their requirement to keep information quiet, they might actually take it one step beyond. And I do remind myself that mediators are not the confidentiality police, that we have a role to play in confidentiality, but so do the parties and so do the court. So, and as long as you are adhering to your ethical requirements, if there is a violation of confidentiality or if there's some confusion about it, the issue goes back to the court. The issue does not go back or involve the mediator unless, there is further court action and the mediator is summoned or some other issue that asks them to come before the court. But that it's not the mediator's responsibility to police the parties to make sure that they're adhering to their obligations.
Right, and I could even imagine scenarios where that would itself violate some of the confidentiality and some of the other responsibilities that mediators have. So, yeah, that's a very good point, Kimberly.
Okay, well, I think, Tad, we have so far in 2021, we have 5 written opinions. So we're a little bit more than halfway through the year. I know that the MEAC has a couple of opinions pending before them. So 2021 will not end with the 5 opinions that we have covered today. We've got, the MEAC's got a few more in there. We've gotten a number of questions, Tad. So what I'm going to do is I'm going to stop sharing our screen. And if you don't mind, I'm going to share some of the questions with you and we'll see if we can get some of these answered. All right. So, okay. Okay, this question comes in. It says, if both parties are pro se, must the mediator write the agreement or request one of the parties write it for both parties?
Yeah, I mean, the mediator has the responsibility to make sure. I was trying to find the exact word. Once again, I try to go back to the exact words of the rule, but they have a responsibility to ensure that it is memorialized appropriately. That may include writing it. I mean, if you know for a fact that there's an agreement and know for a fact that there's no way that it's going to get executed otherwise, but there's a lot of there are very few absolutes. And so getting back to, I'm trying to find.
And Tad, I have a feeling that the question comes in from somebody who might be a small claims mediator. And just in case we're looking at it from that frame of small claims, there is the expectation in small claims court, in your role as mediator, that you will write the agreement. We do our county mediation training. And we do teach people how to write agreements. If the agreement is not submitted, there needs to be local procedures for how the agreement will be submitted thereafter. If your program is used to having them submitted afterwards. But I think on this one, Tad, too, in addition to the ethical rules, that they should probably look to their own local practices.
Right. Yes. And I am looking at things from the statewide basis, and that is always the first thing that you need to do is look at your local AOs, your local rules, and your local practices, and make sure that you're following those. And then also the rule is 10.420C. The mediator shall cause the terms of any agreement reached to be memorialized appropriately and discuss with the parties and counsel the process for formalization and implementation of the agreement. So there is some responsibility, but it may just simply be the responsibility of ensuring that the parties say, we're going to take care of it. I don't think the mediators, once again, as you said in discussing that last question, is to be the police or anything, but they do, as you pointed out in one of the other ones, they need to make sure that before they file their report, that their report is accurate as far as whether an agreement was legally reached.
Okay, great. We've got another question in here dealing with MEAC opinion 2021-005, the last opinion we went over. If the parties are waiving confidentiality for the mediator to speak to the court regarding mediation, does confidentiality have to be waived in writing, or is a verbal waiver enough?
The rule 10.360 confidentiality says a mediator shall maintain confidentiality of all information revealed during mediation except where disclosure is required or permitted by law or is agreed by all parties. This does not require on its face it to be in writing, but this is one of those situations where a best practice is, if at all possible, is to probably get it in writing. But as long as there is some agreement by all parties, that is the way it can be waived.
Okay, right. Yes. And I was going to say, it's always good to go back and look at those exact words, Tad, and then to note the difference between an ethical requirement and a good practice procedure.
Right. Exactly. That's exactly.
Well, and here's kind of a question that I should have asked you first. How do parties waive? What do they actually have to do?
Well, and that comes, as you see, the rule is pretty broad, and the application of it is it doesn't tell you exactly what they have to do or exactly what you as a mediator have to do in the situation, but the point is that they have to agree. And so I would analogize it to to a contract. You have to be able to, and just like not all contracts have to be written, this agreement doesn't necessarily, but as we said, it's probably a best or better practice to have it written. And I think that, the parties would be able to, and we kind of brushed up against this issue in one of I think 005, but the parties could waive, I'm presuming, for only a particular purpose. I don't know that, but it's like you said, it's the party's privilege, it's the party's confidentiality. And I think that if they waive it for only a particular circumstance, the media would probably be, it would probably be a better practice to make sure to stay within the bounds of what the parties have agreed to.
Okay, great. So I'm just going through and looking at some of our questions. Some of them are on similar topics. So, but I did have one that was here that said, again, it's on this translation issue, and I'm sorry, I've been scrolling. And is it okay to have, one of the questions is it okay to have an attorney for the party serving as the interpreter?
That, similar to the question that the MEAC declined to answer, that implicates the there are rules that apply to interpreters. There are rules that apply, of course, to attorneys, and that issue would have to be addressed through the process and by reviewing the rules applicable to the attorney's position, not necessarily from the mediator or the mediation's position. So I would just decline to answer that one, because I would just, it's too sticky of a situation with trying to opine about other professions' rules.
Mm-hmm. So I have another question regarding a translator. What happens if a party says he or she cannot afford a translator but is not indigent?
I would probably say I hesitate to answer that one, but I would probably say that once again, if we can analogize things to other situations, sometimes it helps us to analyze the situation, the question, and it just would be similar to if someone is just illiterate, because basically not being able to translate is being illiterate in one of two languages. So what would you do in that situation? I mean, so you go back to the rule that says the mediator shall cause the terms of any agreement reached to be memorialized appropriately. That, like I said, professional translation is a separate service. The MEAC opinion that we discussed establishes that simply functioning bilingually is not a violation of the rules. And so, I mean, it's that's an interesting question though, but it's one of those that's
it does, and it hits at the heart of what services too can the court provide. And as we know, there's a limit on some types of services, and some services I'm not sure if translation services are offered in trial court operations in other regard. But also while you were talking, I was thinking about, again, it would be something that you would probably want to talk to up front with the parties. And I assume this might be a shared cost. Wouldn't be just one party paying, because if a document's being reduced into a language that the mediator can write, let's just say Creole, and both parties speak Creole, the mediator speaks Creole, and that's what it's written in, that it would be an obligation for both parties, just like the fee is typically split for the mediator between the parties, or is appropriately divided.
Right,
it just wouldn't be
but
one
but I think that if the mediator can function in the writing, I mean, as long as they don't charge it as a separate service, as long as it's just like they would in English, quickly fill out the form, write it down, whatever. And, it probably, once again, like I said, functioning bilingually is different than providing the service of translation separately. And once again, and I'm going to have to point out that I have been sometimes thinking more generally about the mediation world, and with court interpretation, court mediation units, as we pointed out earlier, check with your circuit, your county, check with your court about policies, procedures, and those kind of things. So we've been opining and going over these questions that were much more general in nature, maybe than so that just a private mediator out on their own would maybe be able to do one thing. But if your court has an AO or a policy that prohibits that, then you're confined by that AO or that policy unless you get some sort of an exception to it.
Great. Now I have one that really has to do with technology in the age of the future. In 2001-002, if the mediator drops the agreement into Google Translate, is that a violation of dual roles or a valid use of technology?
Well, now this, of course, presuming that there's not an extra fee charged for this. That's another important thing about the function of a mediator, is there's a lot that goes into going back and forth and talking to people and getting, facilitating this agreement, and then sitting down, at your laptop or with a notepad and writing out an agreement. And you can't charge a separate fee, extra fee for that, an extra service, but as part of the mediation process. Dropping it in Google Translate. Now, one of the things is that Google Translate is an awesome tool for turning something that looks like pure gibberish into into something that you can at least consume. But it is a far cry from a standard being able to function as a contract translator, really. And that's what we're talking about. And especially if it has very much legalese, if you will, the Google Translate will have some shortcomings. But to the point of the question of simply dropping it in there as an assistance to memorializing it, I don't know and don't see where that in and of itself would be a problem. I think the problem would come with the quality of the Google Translate, with the quality of the translation and the translation, not interpretation.
Mm-hmm. And Tad, we've had Christopher Hopkins from the West Palm Beach area join us at our annual conferences for the last couple of years. He is an expert in e-discovery and also all issues kind of online, cybersecurity, and some of the other things. And at one of our plenaries about 2 or 3 years ago, he shared with us a disclaimer that not only he sends out on his engagement letters, but also some disclaimers that he uses on forms because he's using technology. And for example, the disclaimer in his engagement letter talks about how he'll be transmitting information via email. If you have concerns about the information being sent over Gmail, please let him know, because that's how it's going to be done. And I'm oversimplifying his wonderful disclaimer. The other thing he also does is, so it reminded me of this, that if an agreement was going to be signed by parties and it had been translated by Google Translate, maybe that would, maybe including in the agreement that the parties have agreed to use Google Translate for their agreement, or that technology had been used, might be a valuable tool for the mediator. So if any of you out there want to receive Christopher's disclaimer, I would be happy to email it to you. You can reach me through the DRC mail. Many of you may have taken he just spoke at our last conference in August. He has been a perennial favorite of ours, and he has given us permission to share that disclaimer with the field. So maybe that will help also in the use of some other technology items. But it is very interesting, Tad. I started mediating when literally, we wrote with a pen on a 3-part form at the end of the mediation, and we gave the top form to the judge, and the parties left with pink and yellow copies, and that's how mediation agreements were done. There were no typewriters or laptops in the mediation rooms. There were, things were done. We used to joke that you could mediate as long as you had a blank piece of paper and a pencil. And although that's probably still true today, we have come so far in even such a short amount of time with technology. I mean, I doubt any of us in the last 2 years would have imagined that this is where we would be in the fall of 2021.
Yeah, and I agree with what you said, which is that all you really need is a pen and a paper and to mediate, and I think that is still true, and maybe even more simple than that, as all you need is 2 parties that have a good faith intent to try to work things out, and a mediator. I mean, and then of course you have to memorialize it somehow or enforce it some way, but and that's where your pen and paper come in. But I think we're in an era now, like you said, we've been pushed more quickly across the divide between in-person and virtual. And really, I think the in-person aspect of it is never going to go away totally. And humans are social creatures, and we're, especially in certain circumstances, we're going to want to be together, want to be in the same room, want to see someone, a few feet from us. But what the past 18 months, 20 months, whatever it's been, has shown us is the way we can use video and technology in order to bridge gaps, and in order to facilitate, very efficient and very advantageous mediations that might otherwise have taken so many resources and so much time and everything. And it's just really exciting to see. But the last thing I want to say is, because I know we're getting close to time, is you were talking about the engagement letter, or that Chris had given us, and that is a good practice all around. Is if you have a doubt, especially in this time where we are bridging and moving in and out of virtual and stuff, is to make sure to document and make sure that the parties understand how mediation is going to go. One thing about that is that parties are not going to be comfortable if they are being surprised by stuff. So you want to make sure that there are no surprises. And a good way to do that is to just lay everything out. Here's how we're going to do it. Make sure that, as you said, that Gmail and the email was acceptable for the security needs and those kind of things. So, I really think that those kind of things, and think as, people attending the CME are thinking ahead and getting information, and use that information to look forward and to try to avoid problems, because it's always easier to avoid problems than to get out of problems.
Yes, that's very good advice, Tad. And I do see that we're coming up on the close. If we have not gotten to your question, like we promised, and I appreciate that everybody's been good, the Zoom platform memorializes your name for us. We will follow up with you next week on getting you an answer to your question. We certainly appreciate your participation today, and we look forward to working with you in the future. Right. Goodbye, everyone.